May I please your lordships? I beg to mention item number 11 of the daily list, my lord. In this matter, my lord, Senior Counsel King Chaudhary is appearing. He is out of station today. I'm praying for an adjournment today.
Contempt matter.
Contempt matter, my lord. May it come up on Monday, my lord, please.
Let it be called up.
On Monday, man.
Let the matter be called up. We'll
Okay.
see if there is any case for issuing notice, they'll issue the notice, otherwise, we'll adjourn the matter.
Okay. Like.
May please, Justice. I beg to mention item number 17, 17.
Yeah,
This kindly agenda matter for the day. Senior counsel is out of session.
adjourn for a week.
Next week, any date, that may be. Lordship, Thursday and Friday, I have some difficulty, my lord. I'm for the respondent.
You ask for that.
My lord. Wednesday. My lord. I love like.
Please, your lordships. Lordship, I beg to mention item number 3, 4, 5, and 7.
Yeah.
With the consent of all the parties involved and also the appellants in item number 6, I'm praying for an adjournment for the day, your lordship. And humbly praying that the matter may be listed on March
weeks.
12th.
2 weeks. Then after 2 weeks, whatever the date.
March. May I beg your lordship? I beg to mention item 29, supply list, lordship.
Yes,
Lordship, kindly the matter may be taken up on Tuesday because the engaged counsel is out of station, lordship.
adjourn.
Daily list for orders, item 1. Item 1 and 2.
Look here. On 23. On 23rd February 2023. Time was granted to the counsel appearing on behalf of the petitioner to complete his instructions for appearance on behalf of the petitioner, since the advocate engaged by the petitioner, Mr. N.N. Karmakar, has passed away. Full stop. Thereafter, on 8/6/2023, again, time was granted to the petitioner to engage a counsel of choice to argue the writ petitions. On 14/11/2023, again, time was granted for the same. And on 4/1/2024, this court has directed to notify the petitioner for making alternative arrangements. As per the office report, the notice issued to the petitioner was served through speed post, but till date, none is appearing on behalf of the petitioners. In such circumstances, these writ petitions are dismissed for non-prosecution. 1 and 2, both. 1 and 2, both.
Item number 8 to 10.
Service is not complete on respondent number 7.
May it please your lordship. I'm respondent number 6, your lordship.
6.
Yeah, your lordship. Respondent number 6.
Who is the respondent number 7?
7 is, I think, the lessee, your lordship.
May I please your lordship?
Rule 5, stay of proceeding.
Order 41 rule 5 comes in when there is an appeal.
How the subpoena is maintainable?
This application.
Application is maintainable?
Infrastructure.
Mr. Consul, Mr. Consul, we are. How this writ application is, this interlocutory application is maintainable?
Your lordship, this matter has become infructuous because the tender invited for this
Infectious.
was for the year 2022
That's all-
and 23.
that's all-
Thereby the
that's all.
period has passed.
So, what, IA has become infectious, review petition has
The
also.
entire matter, your lordship,
No, your
it
lordship,
appeal, I am appearing for item number 8 and 9, your lordship. Kajolgaon Weekly Committee, 8 and 9.
The tender is still, this one, till the 4th of, till the 31st of March, I think, your lordship, in this one. The tender, the period is still the,
Whatever it may, once he is saying matters have become infectious, what remains then?
इनका नाम note कर लेते हैं. इनका नाम तो
Applicant. Learned Counsel, Mr. So and so appearing for the
As should, your lordship.
applicants as well as the writ petitioner, review petitioner and the writ petitioners. And the writ petitioner has submitted that these matters have become infectious, dismissed as infectious.
obligations.
8, 9 and 10.
8, 9 and 10.
Item 11.
May I please your lordship. My lord, in this matter, the petitioner, she challenging the order of the,
Not challenging. the
Not
order,
challenging,
Complaining that this
Containing
order
the
passed
order.
by the court has not been.
on 17/10/2020.
Further orders, the applicant TSA authority shall not take any coercive action against the respondent, which she shall be allowed to serve as entitlement. TSA Model Hospital Vedota shall also be pending the petition of the government. What you are complaining now?
My lord, the petitioner has been appearing at her post, has been doing her duty from the month of November.
Yes,
But my lord, she has not been receiving any salary since that. She has, even the authentication, biometric authentication report has been submitted herein. At page number 25, if my lord can peruse.
yes, that is there.
She has been appearing and doing her duty regularly. However, my lord, she has not been paid the salary up till now.
Ordinarily, they should move an IA directly. ठीक है, ये भी.
Should notice to the contempt petition. Returnable on so
Oblige.
6 weeks.
Oblige.
Yes.
Item 12 and 13.
In this case, notice has already been issued, lordship. The other side may fail to file any reply, otherwise.
My lord, in this case, I think CAT has dealt with all the issues, my lord. There is no need to file any reply, my lord.
Lordship, if it's a
Everything
date
is
for
on-
disposal, then lordship.
At the request of the learned concept of the respondent has submitted that there is no requirement of filing counter in this writ appeal, writ petition. Stop. At the request of the learned concept of the applicant, place this matter after a week.
2 weeks.
ये पे benefit दिया है.
This after 2 weeks for admission.
Okay.
Item 14.
नहीं, but ये इनका relief
Yes.
May please your honor. Here the petitioner is a nationalized bank where the opposite party defaulted to repay the amount. So they approached before the district magistrate for passing an order. They have passed the order But when it comes for implementation, bank has given representation, but they are not giving any date or.
Move a representation for the collector, how a mandamus can be issued in this matter.
Yes, your
They have
lordship.
moved an application under section 14.
Yes, but
They have
if
passed an order, if they are not implementing or whatever the authority to whom direction was issued, if he has not done so, move the district magistrate again.
yes, a similar order has been passed earlier in petition number 451. Four, five, one. 2024.
कितनी लोई था?
Fourteen, 15 and 18, 19. 14, 15 and 19. Ms. Bora? You are appearing for this state?
Yes, Lord.
You are in this for the copy of the petition. This item number 14, 15 and 19 are identical. File your response. Okay. Mr. So-and-so is appearing on behalf of the petitioner. Mr. So-and-so is appearing on behalf of the respondents. The consent for the respondents is directed to complete the instructions that what steps the authorities concerned has taken for
Addressing the demands.
the pursuant to the order passed by the district magistrate.
One extra copy. One extra copy.
One extra copy of the petition is supplied to consent for the state during the course of the day. This after 2 weeks. Complete your instructions. 14, 15 and 19.
Deeply.
Apply.
Item 16.
May I please your lordship? Your petitioner challenge the interim order dated N 1 2024 passed by the CAT Guwahati, my lord, where my lord petitioner claim was rejected on the ground. My lord, the deceased employee has not recorded the name of the petitioner in the service record, my lord, prior to his death, which is not correct, my lord. He tried. First, I want to clear my stand, my lord, why I am entitled. My lord, I am the second wife of the deceased employee, my lord. My marriage was legal, I was legally married wife, my lord. My lord, kindly share page number 30.
Marriage took place during the subsistence of the earlier marriage.
My lord,
Subsequent, according to her, no, subsequent.
No, the previous marriage was dissolved.
no, my lord,
She expired according to.
in 2005, my marriage
Only
was
one thing, the OA and the WS has not been annexed, so all the records are not along with the petition. Lordship.
Who is there?
My lord, order is there.
Only order is there, Lordship.
No, who is there? That page. Order is there.
Order is there and our WS is also not there. Stan, that should be. Let to find, throw an additional affidavit in the WS.
Hello.
Then in concept of the petitioner is directed. Place on record the original application filed by the petitioner before the CAT as well as the response filed on behalf of the respondent, Union of India. List after 2 weeks.
My lord. Need your voice.
Item 18.
This is, I am appearing for the Bank of Baroda Lordship. This is a case challenging 13-4 notice Lordship. I challenging a 13-4 notice Lordship. It is, I contend that it is not maintainable because there is a remedy under section 17 of the SARFAESI Act. And there are catena of decisions, including a decision of 2022, which says that petition would not lie. Lordship, so I first object on the maintainability of this petition.
Lordship, I'm being led by Mr. M.K. Chaudhary. Can he pass over just time? He's coming.
For the time being,
Fine.
pass over the time.
Item 20.
Made to the lordships. At the very outset, I must say, my lord, since the matter touches upon a SARFAESI proceeding, it's quite natural to have a view that we should go to DRT. But for a moment, in my attempt to persuade my lords, my lord, may I pass over these two judgments of this honorable court division bench, my lord. We are not assailing the proceeding. We are not assailing the sale recovery proceeding, auction sale. What we are on is that the recovery be made after correct valuation of the property. A nationalized bank is not following the law. My lord may have the next page, paragraph 9. If lordship permits me. Paragraph 9 at next page, if I may read. Paragraph 10.
They put to auction your property after assessing the same.
What they have
making
done.
the
my lord.
valuation of the same.
Absolutely, they have not carried out the valuation, went ahead with the sale. Since we had the right of exemption, but we could not.
Raise all your objections before the DRT.
My lordships, for a moment, if I may try to persuade my lord.
Yes.
Their action is not a consequential action pursuant to a DRT proceeding. They have initiated the notice only in their action of under the act. Fair enough. The act requires them to carry out a valuation prior to sale.
Raise this point before the DRT.
Then my vacation notice, my lord, that is on the.
That is,
That
is for the DRT to take into consideration. That's all.
My lordships, if I may try to
But it
rephrase.
may be whatever available grounds, you can raise all those grounds before the DRT, not before this court.
I understand, my lord. May I place it this way? I rephrase my submissions, my lord, with all respect. Even if I am not on the DRT proceeding or sale or auction, whatever they do, may I pray before your lord that in consideration of this order by this division, honorable division bench, my lord, a statutory authority not following the statutory rules was required to do that much intervention, my lord. If I may read this paragraph, having regard to the above without interfering with the recovery process, we direct the bank to consider the borrower's plea for a just valuation of the mortgage assets, and then only after assessing the correct market price, the reserve price for the sale should be fixed. That much, my lord.
We are not.
That much.
You approach the DRT, raise this issue, will issue a direction to the DRT to consider the same and decide in accordance with law. That's all.
Till then,
No, not till then.
Your lordship,
Is
sale
that
has
name-
concluded.
Hmm?
Sale has already been concluded.
No, they have not paid the price, the 25% price, and the rest have not been paid.
Whatever. We are not concerned.
I know.
That is for the bank.
I understand.
The sale will fail or not.
But one liner from your lordship can save me from being rendered homeless, my lord. That much.
Not at all, sir. No, this is, once we are relegated you to the DRT, while granting you liberty to raise this question before the DRT with a direction to the DRT to consider the same and pass a speaking order. That's
Very well, very well. Not like recommendation.
the state petition is filed by the petitioner. Being agreed with the action of the respondent bank initiated the section 13(4) of the Securitization Control Act. Full stop. Having heard the learned concept for that petitioner as well as the concept for the respondent, we are of the view that the petitioner is having an alternate and efficacious remedy to approach the DRT under section 17 of the SARFAESI Act 2002. Full stop. The concept of the petitioner has submitted that the respondent bank authorities has not conducted a valuation of the property in question in accordance with law. Having considered the same, we deem it proper to direct to grant liberty to the petitioner to raise the question regarding the valuation of the property in question before the DRT. If any such question is raised by the petitioner before the DRT, the DRT shall consider and decide the same strictly in accordance with law by a speaking order. With these observations, the said petition is disposed of.
I'm grateful of license. This would help. Grateful.
Passover matter 18.
I'm sorry, my lord, I was a little late. Now, I'd like to draw your lordship's attention to the earlier order passed by this honorable court. When there was a demand notice, the petitioner approached this honorable court. And this honorable court was pleased to pass an order which your lordship will find at page 76. That was an agreed order by which the petitioner was directed to file a further representation. Operative part, your lordship will find at page 79.
Yes,
The operative part, your lordship will find at page 79.
79.
Second paragraph.
Yes.
In peculiar facts and circumstances of this case, instead of exercising extraordinary jurisdiction of this court under 226, which may entail disputed question of fact that are raised in this petition, including the question whether the bank has rightly declared the account of the petitioner as NPA or not, it would be appropriate to relegate the petitioner to file further detailed representation as provided under section 13(3)(a) of the SARFAESI Act, and the same shall be considered by the respondent bank as provided under section 13(3)(a), keeping in mind the proviso of the said provision, and pass a reasoned order within a period of 2 months from the date of receipt of the certified copy of this order, and the same may be communicated to the petitioner. It goes without saying that the notice under section 13(2) dated 2/5/2022 shall remain as it is, and only after considering the representation that may be filed by the petitioner as per this order, if any further proceedings are necessary as contemplated under the SARFAESI Act, shall be taken by the respondents. Pursuant to this, the petitioner filed a detailed representation that has not been, my lord, responded to. Then, my lord, the notice at page 124 has been issued, possession notice. Page 124.
Yes.
This possession notice has been issued. The undersigned being the authorized officer of the Bank of Baroda under the Securitization and Liquidation Surface Act in exercise of power conferred under Section 1312, read with Rule 3 of the Security of Rules 2002, issued a demand notice dated 2/5/2022. That was what was said, the subject matter of the earlier writ petition. Then pursuant to this possession notice has been issued. So my lord, my representation has not been considered or disposed of.
Write a contempt petition for that. Like contempt petition, if you are so advised, the concept is advised, and so far as regarding 13(4) is concerned, this position notice approach the DRT.
But in the meantime, my lord, this possession notice,
Whatever it may be said, approach the DRT has power to grant stay. They'll consider it, and if they deem it proper, they grant stay. We are not entertaining.
but my lord, in the contempt petition,
The whole thing, earlier also this petition was entertained for whatever reason.
yes.
That's why only again you come to, otherwise at that time also if you were relegated to DRT by now, by this time, it would have been disposed of or whatever the.
Quite true, my lord. But at the same time, my lord, this honorable court was pleased to pass an order, and that has to be carried out by them.
Yes, that certainly, then file a contempt plea for that, we'll consider it whether there is any contempt or not.
The only, my lord,
Execution, it's not a executing court.
this is a notice of possession, man. Now, in contempt petition, I cannot pray for a, my lord, stay of this.
Whatever it may be, then you go before the DRT and pray for the stay.
My lord, your lordship's order has not been complied with.
That's between us and the respondent. Whenever you raise this plea, we'll consider it, whether they have complied with or not. If they have not complied with what necessary
But
order we have to
non-compliance-
pass, we'll pass. that order.
Non-compliance has led to,
It is your duty to brought into the notice of the court. We'll consider it.
my lord, the non-compliance has led to issuing of this order, my lord.
That file a contempt petition, whatever the response could be, we'll consider it, and that.
Let them, my lord, let them say whether they have considered or passed this order or not. my lord.
So far as regarding this petition is concerned, you have challenged the possession notice. For that, you have a remedy to approach the DRT.
But this is contrary to the, what your lordship directed.
Supreme Court has deprecated this practice in so many words in many judgments, and recent judgments of 2022 also. So we are not inclined to.
But then, my lord, the earlier order has attained finality, my lord. They have not raised any grievance against that.
If they have not complied with those directions, file a plea, proper plea before it, this court will consider it. By this petition, essentially, the petitioner has challenged the possession notice issued by the respondent bank while exercising powers under section 13(4) of the Securitization so and so Act. Full stop. And in concept of the petitioner has submitted that earlier, the petitioner has approached this court by way of filing WPC number 3894 of 2022, wherein 2022, and the said petition was disposed of by this court while directing the respondent bank to consider the representation filed, the representation filed by the petitioner under section 13, bracket 3, capital A, bracket close of SARFAESI Act, and also issued a direction to the respondent, the bank, to consider the same, keeping in mind the proviso to the said provision, and pass the reasoned order within a period of 2 months. Planet Council has submitted that the said direction given by this court has not been complied with. Stop. We are of the view that if any direction passed by this court in earlier, if the petition has not been complied with, the petitioner can very well file a contempt petition for non-compliance of the court's order. So far as regarding the possession notice issued by the respondent bank dated
12/1 to 2024.
Which date?
12/1, 12 of
12/1/2024 is concerned, the petitioner has an alternate and application remedy to approach the DRT under section 17 of the Surface Act. Hence, we are not inclined to entertain this petition. The same is hereby dismissed with liberty to the petitioner to approach the DRT under section 17 of the.
My lord, may I say
Deeply
that, my lord, I'll
obliged.
approach within a week. Till that time, my lord, this may be suspended.
Space.
Item 21.
Obliged.
May it please your lordship, may I have your lordship's permission to address your lordship to the virtual mode,
Yes.
my lords? My lords, 16 students are before your lordships. It was heard on earlier occasion also. And in one of your lordship's order in December, your lordship, the Learned Council for the university was directed to seek instruction as to whether some equitable measures can be done to provide relief to the 16 students before your lordship. The matter in nutshell, my lords,
Where is that order?
my lord, that is 8th of December 2023. Really, my lord, before that also, 17/11/2023.
8th of December 2023.
My lords, if your
Order
lordship
is there on the order sheet.
V.K. Barua Learned Council for the Bodoland University. 3 weeks time to receive instructions. My lord has 8th of December 23, and really it fell from your lordships on 17/11/23, though it is not recorded in that order.
My lord, I had received instruction from the university, my lord. Well, my instruction is that, my lord, as per regulation, they have already availed their 3 chances to clear their backlog. Now it is 4th chance. Under the regulation, they cannot be allowed 4th chance. However, my lord, your lordship, whatever order your lordship passed, who shall be ordered.
My lord,
Regulation.
my lords, may I please the facts of the case, my lords, then? My lords, the writ petition assails 2 provisions, 5.3 and 19.6 of the Bodoland University regulation. Now, basically, my lords, under the
Just a minute,
UGC
Mr. Kosaru, just a minute.
My lords, my lords.
Then, Mr. Council, it requires some consideration, so
My lord, that is true, my lord.
we'll place this matter for hearing.
My lord, as your lordship.
We'll admit this and place this matter for hearing. Then we'll consider it. Okay. Mr. V.K. Barua, Learned Council appearing for the respondent university. Learned Council appearing for the respondent university has submitted that the university has instructed submitted that he is in receipt of instructions from the university that since the students have already availed 3 chances for appearance for appearing in the examination, clearing the backlog. For clearing the backlog, no further chance can be given as per the regulations of the university. Full stop. Having heard the Learned Council for the parties and after going through the controversy involved in this petition. We are of the opinion that matter requires consideration, hence admit no need to issue notice to the respondents as parties are already represented. This matter for hearing in the month of
No, whatever convenience, I'm
June 2024.
deeply obliged, my lord.
Item
Deeply
22.
obliged.
May I please? May I please, your lordship, my apologies, lordship. In the cause list, name of standing counsel High Court was not reflected. That's why we missed this case today, lordship.
Lordship, apart from that, your lordship, we have also filed an affidavit today, your lordship, just now, your lordship, on behalf of respondent number 3, your lordship. The matter may come up along with the affidavit we have filed on behalf of respondent number 3. Your lordship.
Name of my
Who is
senior,
appearing for the council now?
TJ Mahanta, lordship, senior counsel, Mr. TJ Mahanta.
Okay. In the learning council, Ms. So has submitted that the name of senior counsel D. Mehta,
TJ Mahanta.
TJ Mahanta, lordship.
TJ Mehta is not shown in the call list. And therefore, is not shown in the call list, and therefore the registry be directed to reflect the name of Mr. Mehta in the call list. Full stop. Learned counsel appearing for the respondent has submitted that.
Respondent number 3, your
The
lordship.
respondent number 3 has submitted that a counter, a counter to the writ petition is filed on behalf of them today only, on behalf of the respondent number 3 today only. Full stop. This matter after 2 weeks, while reflecting name of Mr. Mahanta in the cause list, the response filed by the respondent 3 be also placed on record.
Deeply obliged, your lordship.
Obliged, lordship.
Item 23 to 25.
May I please, my lord? My lord, the bid of the sole respondent, my lord, was rejected by the railway authorities at the threshold, my lord. The financial eligibility criteria was not fulfilled by the respondent, my lord. My lord, the tender notice was issued on 7/4/2021. And my lord, phase 108 is the tender notice. And my lord, will take phase 109. Phase 109, my lord, at the bottom clause, capital B, financial eligibility criteria. May I read, my lord, that criteria? The tender, may I read, my lord? Page 109.
Tender conditions number,
My lord, the tender starts from page 108, my lord, page 109 at the bottom, my lord, clause, capital B, my lord.
108.
It is financial eligibility criteria in bold letters, my lord, it is mentioned.
108,
109, my lord.
109.
9, my lord.
Yes,
At the bottom, my lord, the tenderer must have received contractual payments in the previous 3 financial years and the current financial year up to the date of inviting tender, at least 150% of the advertised value of the tender. The tenderer shall submit certificate to this effect, which may be an attested certificate from the concerned department or audited department of the client or audited balance sheet duly certified by the chartered accountant, certificate from the chartered accountant duly supported by the audited balance sheet. Now, my lord, the certificate is at page 159. Pursuant to this tender condition, page 159 is the certificate. And this certificate is, my lord, by a proprietorship firm, not by the LLP. The participation in the tender process was by an LLP. Whereas, my lord, at page 159, the 3 financial years contractual payment which were supposed to be submitted, my lord, page 159, my lord, will take it. Page 159, my lord. This is the certificate by a proprietorship firm, Messrs. Babulnath Contractor. My lord will see the financial years 2015, 16, 16, 17, 17, 18, 18, 19, and 19, 20. And on this ground, my lord, the tender evaluation committee has rejected the bid of the petitioner at the threshold stage. The matter has not gone to the stage of bid evaluation, my lord, which in my humble submission, the learned single judge, my lord, had proceeded on a wrong factual premises. My lord, page 199, my lord, now I will take.
जिसका काम किया और ऑडिटेड बैलेंस शीट विद सर्टिफिकेट रिटर्न उनको मॉनेटरी डॉक्यूमेंट दिखा एक तो या तो सर्टिफिकेट फ्रॉम द डिपार्टमेंट की लेवल प्राइवेट पार्टी है तो क्लाइंट और नहीं तो कभी बैलेंस शीट सर्टिफिकेट चार्ट देता उन्होंने चार्टेड अकाउंटेंट के साथ
Page 199 is the rejection order by the tender evaluation committee, my lord, wherein the reasons were specified. Page 199.
199.
199. Last paragraph, my lord.
Yes.
May I read now? As per Babulnath Infra Projects LLP agreement dated 3/4/17 that was signed on 24/5/17, the Babulnath proprietor has made a partnership LLP which desires to take over existing civil construction business from proprietorship firm. Later on, the name of Babulnath Infra Project LLP was changed to BN Infra Projects LLP on 14/9/18. As per the tender conditions, para 9, the credentials of proprietorship firm Messrs. Babulnath earned after the date of becoming a partner of the firm Babulnath Infra Project shall not be added in Babulnath Infra Projects LLP or BN Infra Projects LLP. Therefore, the credentials of financial eligibility of Messrs. Babulnath proprietor cannot be considered for Messrs. BN Infra LLP after the formation of the partnership firm.
Just a minute. Just
My lord.
नहीं partnership. We tendered here with BN projects. Then the credentials we have submitted is as good operator. But the clause says It's tender. Tender is not the tender here. Company.
Price bid has not yet been opened. Price bid has not
No,
been
my
opened.
lord, the challenge was made after the LOA was issued. His bid was rejected at the threshold, my lord.
So he submitted tender in the name of BN projects,
BN Infra project.
Infra project.
Yes.
And the certificate is
Of
relying
the
upon
proprietorship.
proprietorship.
That is the ground for rejection.
Including a technical business outcome. The price bid for the tender certificate LOI bid. Then what is that? Apart from the other thing. Yes, central government, the railway.
This is a railway project.
My lord.
Railway project.
So you come to the court after the LOA was issued.
My lord, we challenge the tender issued in favor of the private
after
respondent.
LOI.
The private respondent did not even appear before the read court. And the finding, if I may take your lordship to the finding arrived in by the learned single judge in the read petition. If I may take your lordship to the read appeal number 383 of 2023.
The judgment is dated.
Judgment is of my lord.
This 22nd of December.
Yes.
Yes. Which matter you are
And so far as my lord, the bid value is concerned, the private respondent, my lord, who did not even appear before the read court, submitted a bid which is 7 crores, my lord, more in my lord amount than the bid submitted by the respondent herein. There is one issue. One more issue is, my lord, the LLP was created in the year 2017, and for recognition, he has submitted an application before the authority to recognize the name of the LLP, because all along he was working with the railway as a sole proprietorship firm.
Fine.
And if I may take your lordship to the tender condition, the partnership firm, after creation of the partnership firm, if he has worked in the name of partnership firm, the amount of experience that is gained, my lord, in the way of working as a partnership will not be considered. But here is the case is little bit different. That's where the learned single just come to a finding in paragraph, my lord, 29, page 53. If I may take your lordship to the finding. Page 53 of read appeal number 383.
Yes.
The dispute as have been elaborated above hinges upon the evaluation of bid capacity by interpretation clause 2C1, 3, 9, and 10. The formula which has been adopted for making the said evaluation is not under challenge, and perhaps cannot be a matter of challenge also. It is within the exclusive domain of the owner. However, the application of the facts and circumstances on the said formula can be looked into as it forms a part of the decision-making process, and more so. When in the instant case, the specific allegation is of an incorrect application. For the same, the veil will have to be lifted. Clause 3 makes it clear that in case of a newly formed entity, the credentials of one of the constituents in an earlier entity would be to the extent of a share on the date of dissolution and a share in the newly formed entity. In the instant case, however, the earlier entity was Messrs. Babulnath, which was proprietorship firm, and there is no manner of doubt that the sole proprietor is one Sri Babulnath. It is the said individual who had later formed the LLP, which is the petitioner number 1, bidder in the instant cases. is an LLP of which Messrs. Babulnath, the proprietorship firm, is one of the constituents. In that view of the matter, so far as the credentials of Mr. Babulnath is concerned, there being only one proprietor, the entire credentials still forming of the LLP has to be taken into consideration along with its share in the newly formed LLP. Paragraph 30, the dispute, second dispute is with
Just
Which can be executed by the entirely based on agriculture. Where if we want to agree with this law, we can communicate at the beginning. They have followed the process is not complete. Then we proceed.
on the, I'm sorry.
What is the present position?
But
Work has been
Work
solved.
is almost completed, 90%.
Work is almost complete. There is no stay order.
There is no stay,
But there was a status
subject to
quo.
outcome. It was subject to outcome, there was no stay.
In which proceeding? In the writ appeal?
Yes, no, the writ petition,
Subject to outcome.
subject to outcome.
And then,
The final decision order, my lord, was to, my lord, redo the exercise, my lord, and allot if the remaining work is there. Page 55, my lord, paragraph 33. 33. Direction was to, my lord, redo the exercise of valuation of the bid.
Taking a public interest involved and there's a allowed directing redo the exercise of evaluation of bid in the manner indicated. Properly done.
And if, my lord, found to
Since it
be
is
correct,
intended that the petitioner such a
handed over.
would be in the bid capacity is the problem and it has to be correct, the work remaining part of the same way.
And my lord, one more important thing, on the basis of the same credentials, I was allotted the other works, my lord, where the criteria were.
That's maybe a, but now since the work is almost complete, what to again redo the exercise, what will be the result of that exercise?
My lord, for that, my lord, some dates would be important, the, my lord, action on the part of the railway in lingering this matter.
If you are aggrieved by that condition, which they have, on the basis of which they have rejected your, you should have challenged that condition prior to the filing of the, prior to submission of your technical bid.
I am not agreed by the condition, my lord, per se, my lord. The conditions are in fact in my favor. Because the condition, if I may take a lordship, the condition one is once again, page 143. It will make it clear that, my lord, if, my lord, after formation,
Not the
We'll
proprietor.
consider it. Be clear. Having heard the learned concept of the parties. And after going through the ensuing judgment passed by the learned single judge. We are of the view that the matter requires consideration, hence admits no need to issue notice to the parties as they are represented to their counsel. However, the direction given by this, given by the learned single judge to redo the exercise of evaluation of the bid capacity of the petitioner number one and two
by the improved order.
and two handed, and to hand over the work public remaining part to the petitioner number one. If the price quoted by the petitioner number one is found to be lesser in the impugned judgment dated 3/2/2023 shall remain state. This matter for hearing. When
That's convenience, my lord.
August 2024, in the month of August 2024.
My lord. Oblige.
Item 26.
But on behalf of the Chief Secretary, we are required to file the affidavit. Well, the
Which one? Item number 26.
item 26, well, my instruction is that they have instructed me to pay for 2 weeks' time, the instruction has not come yet.
What is it?
But they have challenged the rule 13 of the conduct rules 1965.
Yes, Mr.
But the records are very old, so they need 2 weeks' time.
My lord, in this case, my lord, we have basically challenged the with regard to grant of prior permission for pursuing the higher studies in respect of the teachers who are serving in the schools, my lord.
You have challenged that rule.
That rule, my lord. Because, my lord, we just
If you are the government servant, you are required to seek permission from the authorities concerned for pursuing further studies.
my lord, what happened, my lord, the pursuant to that, my lord, they have since 1965 to 2022, my lord, there was no such bindings, there was no such circular upon and all the teachers, those who are not having the master degree, they have pursued their master degree, my lord, on online.
If now they have made a provision of this effect, what's wrong in that?
Now we are,
Whether it is not within the competence of the state.
they have made it, well, it is in the 1965 rules is there, but after that, my lord, after that, my lord, in the year 1965, there was.
Then council, Mr. Not fitting for the respondent state. Respondent number?
But here I am appearing for
Chief Secretary.
the newly implemented respondent, respondent number 5.
Respondent number 5, place for and granted to file count to the petition time place for is granted. List after 4 weeks.
I'll pray for a date, my lord.
After 4 weeks, whatever date of the choice.
4, 5, 5, sorry, my lord, it's the respondent number 3.
Respondent number 3.
Problem.
Item 27.
Yes.
My lord, I am appearing for the respondents, my lord. Petitioner is not ready.
Then no one is appearing on behalf of the petitioner. List after 8 weeks.
Item 28.
May it please. Lord, in this writ petition, we had challenged the rule of the mineral concession rules, my lord. Now, my lord, on reconsideration, we believe that pressing that first prayer, challenging the rule may not be necessary, and we want to pursue the other release, my lord.
Single bench.
Yes.
By this petition, the petitioner has challenged the validity of the rule. Which is that rule?
37.3.3, my lord.
37.3.
Roman 3.
And then Roman 3 of the Mines and Minerals in bracket Development and Regulation Act 1957. Then a concept of the petitioner submitted that submitted on instructions that challenge to the virus of the said provision is not pressed. Full stop. In such circumstances, when the challenge to the virus is not pressed, we deem it appropriate to direct the registry to list this writ petition before the single bench. As per roster.
Interim to continue.
Interim is also there.
Yes, my lord. There was an undertaking, my lord, on 13 to 23.
2023. What is it?
The first order.
Undertaking.
Yes. That they'll not go ahead for a retained agreement.
Till the next listing. Till the next listing, the undertaking in by Additional Advocate General Assam on 14/3/2023 shall remain in currency.
Deeply appreciated.
Supplementary list, item 30 for orders.
May I please, your lordship?
Yes, Mr.
Lordship, Here, Lordship, I have directed to take steps by paper publication.
Yesterday only.
No, that Lordship has been published, Lordship. I have to collect the copies. But my friend says that he
Yesterday
appears for all
only.
the.
Yesterday only someone was published.
You are
and-
appearing for all the respondents?
Yes, I will undertake to appear for all the respondents except 671. There is no such person exist under the 671.
71.
671.
759, Lordship.
All are the employees of Mizoram University.
But why have you denied them? The matter has been already resolved.
No, Lordship, there are subsequent, Lordship, there are notifications. It has been classified as a separate class.
You have not recalled the 93 notification.
Here, Lordship, there is a difference between the class of employees, those who were continuing under the NEHU, they would have got. These are subsequent appointments, Lordship, in the Mizoram University. That is.
How can you make a distinction?
Lordship, I will try to satisfy Lordship.
759, the finance officer, Mizoram University.
Yes, all,
You are appearing on behalf of him,
yes.
but you are.
No, Lordship, the private respondents are till 7:55.
That's one number 6.
755, all the private respondents.
All the. Order.
671, seek instruction. You can appear from her also.
He's saying I don't.
इस नाम का कोई है ही नहीं।
जो भी है।
ठीक है। Learned Counsel for the appellant has submitted that paper publication for service of notice upon the respondent has already been affected. Full stop. Mr. So and so put an appearance on behalf of all the respondents. Services therefore complete.
Within 11 days.
Except 671.
We'll condone the delay.
If the no such person is there, what to remain with the, we will presume that you are appearing for all the respondents. Delay is there.
Delay is there. We will file an objection.
Objection of.
Objection.
Know the delay.
Delay is 112 days.
There is not much. The IA filed on behalf of the respondent, on behalf of the appellant for condoning the
11, Lordship.
11 days is allowed. The delay of 111 days in filing the present appeal is condoned. A connected appeal is condoned. IA is disposed of. Registry is directed to register the connected appeal and list this list the same for admission
After 2 weeks.
after 3 weeks.
By showing the name of Mr. Das as the counsel for the respondent.
Yes, Dash.
Yes, Das.
So.